Hello, my name is attorney Masa Sam Foray, and I am founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to answer all of your Illinois family law matters. So today's question is, I lost my job a few months ago, and I recently got a letter stating that my license was suspended. What should I do? So I want to give you 3 pointers, 3 takeaways from this video, because this is one of these most common scenarios that we as family law attorneys see with our clientele or potential clients. You get a letter in the mail from the Secretary of State and it says your license is suspended or it will be suspended on X date. What should you do? 3 things. Number 1, do not ignore the letter. Do not ignore the letter. There are a lot of people that get caught up in the criminal justice system for something as simple as driving without a license or driving on a revoked license. It does not matter what the reason for the revocation or the reason for the suspension is. If you have a suspended driver's license and you drive in the state of Illinois, it's illegal and it is an arrestable offense. So don't put yourself in that situation. Face it head on and address it. So what should you do? Number 2, don't ignore the letter. Hopefully take it to an attorney if you have the resources to do so. Or if you don't have the resources to take it to an attorney, then you should absolutely pick up the phone and call the number listed on the letter. You'll note that if you're looking at one of those letters, that is not a court order. It's not a court summons. It would be a letter, if you're in Illinois, from the Illinois Secretary of State, or the Department of Healthcare and Family Services, indicating that the Illinois Secretary of State is going to be suspending your license for failure to pay child support. So you need to call the Secretary of State and ask to be put on a payment plan. A lot of people don't realize that even if your license is suspended for failure to pay child support, there are some people that owe tens of thousands of dollars. There are people who owe 6 figures in child support. And so they automatically get concerned sometimes that if they call the Secretary of State, the Secretary of State would say something like you have to pay the entire amount. That's normally not the case. And it's definitely normally not the case the first time around. So if this is a first suspension, meaning you have never ever before been suspended for failure to pay child support, then you can ask the state to put you on a payment plan. Just know that those payment plans are only offered once in a lifetime. After that, if you renege or default rather on your payment plan, the Secretary of State will never again allow you to be on a payment plan. So even if you owe that 6 figures of past due child support, you would have to pay every single dollar of that, including the interest, before they reinstated your license. So you don't want to put yourself in that situation. If you get on a payment plan, honor the terms of the payment plan because it's a once in a lifetime opportunity in Illinois. The other thing that you can do, however, is that you could file motions in courts. You can file a motion with asking the court to, enter an order to give you a hardship license, or to enter an order allowing you to drive, during working hours, maybe just Monday through Friday, 9 a.m. to 5 p.m. Those orders aren't entered every single day, and that would require you to file a motion in court before a judge. And then Secretary of State would then have to comply with the court's order because the court can't give you a driver's license, neither can they take it away. But they would be able, as a person, as the agency that is governed with enforcing child support orders, they would be able to enter an order stating that it's okay with me, Judge so-and-so at the Daily Center, who is presiding over this individual's case, if they drive from if they were able to drive from 9 a.m. to 5 p.m. Monday through Friday for purposes of transporting themselves back and forth to work. And then hopefully the Secretary of State would then follow and comply with the court's order and give you such a license. And then also as a part of this part 3, when we say, you can file motions in court, the other motion that you should be aware of is if you are still currently underemployed or if you are still currently unemployed, the onus is on you as the obligor or the payor, the person who is obligated to pay child support. The onus is on you to file motions to modify or to temporarily terminate or abate your child support. So anytime a child support order is entered, of course the court expects you to pay the child support as long as your circumstances remain the same. But if your circumstances change because of involuntarily losing your employment, because your hours were substantially cut at work, because something else has occurred, that has significantly impacted your ability to earn income, then not only do you have the option or the right to file a motion to terminate, to abate, or to modify your child support, but you have the obligation to do so. There are a lot of people who lose their employment. They know they have this child support order that's sort of been hanging out there because money is being automatically deducted from their paycheck. And so then when they go on unemployment benefits, and they start receiving their weekly unemployment benefits, they think, especially if unemployment is also withholding some money for their children, that has somehow stopped or temporarily terminated their child support order. So they don't realize that during these periods of unemployment, the unemployment agency, or IDES, is not talking and speaking to the Secretary of State. They're not talking and speaking to the court about your specific case. So one hand doesn't necessarily know what the other hand is doing, because these are all very separate entities. So every time you lose your job, if you're a construction worker and you only work seasonally, or you're an individual who has lost a significant amount of income involuntarily, you have to go to court and file your petition. As long as you are being honest and truthful and candid to the court about your substantial change in circumstances, the court will modify your child support, and they will terminate your child support during the periods of unemployment. So it's not a very, very difficult motion to file. There are motions that are filed every day and granted every day in Illinois, but you have to fight for yourself, you have to advocate for yourself, and you have to get into court in order to get that relief. And so I hope that this has been helpful. I hope that you understand the 3 takeaways. Don't ignore it. Contact the Secretary of State and file any necessary court petitions. And we look forward to seeing you on the next video.